Trade secret is a business process, something unique about your business that if other people were to know, right, it will mean that you've lost your competitive advantage. The way that we're built as humans, we tend to associate things with things because our brain is like a pattern recognition machine. That's how we operate as human beings. So we make a lot of associations. So when there's a brand for a particular business and that brand is represented by a logo, over time people start to associate that company's logo with what they represent as a business. There's a popular adage that says that if you want to go fast, go alone. If you want to go far, go as a group. So it also applies to scaling. If you want to go far, like you want your startup to still be a going concern in the next 5 years, your first fundamental thing is to figure out, okay, what is the foundation that we're currently operating on? And there are several things that somebody can do with a logo that belongs to a company that they did not register. If somebody else that is not the owner of that business registers the logo, they can use the logo and create another business that is bad and start creating negative public relations for you. Prior to now, there were some videos. I think Shimgozeri also created a video where he talked about like who owns the code, where you've built a platform or you've engaged a number of developers to build something. And then you're now wondering after they are done building, so who owns the intellectual property in the software that they built? Is it the person that built it? Or is it the person that engaged the person to build it? In the course of this presentation, you'll see that there are dynamics to it. You get generally, the person that creates something is a person that owns the copyright in what they've created. But then what does this mean? Like, what's the implication? Are you saying that I paid someone to develop something and the person is the owner of what he has created, right? So you understand how you can actually ensure that what the person has created is yours if you're the one that engaged them to do it. Even in a scenario where the person is an employee of a business, like person is under active employment, if they create the item, it will still belong to them unless certain things are put in place. So that's like what we're going to be learning together in this session. So just bear those fundamental things in mind. Whoever creates the item is the owner. Are we together? All right. There's something interesting that I would like to share. I met someone last week. I was at the African Retail Academy at the Lagos Business School. And the person was telling me that they have been having issues applying to the Advertising Regulatory Council of Nigeria because usually if you want your ad to be compliant, like if you want to put an ad on either Facebook or Instagram, it's a thing. People are looking surprised. This is a thing. Apparently, the Advertising Regulatory Council of Nigeria expects you to actually send them the ad you want to post. And when you've sent it to them, you pay a small administrative fee, I think around 15,000, and then they will approve the ad before you can post the ad. Whoever came up with that initiative, I have no idea because it seems like the person is completely outside of the ecosystem. Because obviously, someone that just wants to put in a 5,000 naira small ad, like, why are you paying the government 15,000 to run a 5,000 naira ad? But the person was just saying that they tried to send the ad and they kept like going back and forth on the content. And then I asked what the person put in the ad. The person said that they put like some call to action, some images, and they were now saying that if there's a human image, the person that owns the image should also give their consent, or they should show that they hired the person like as an actor or like a creator that is collaborating with them. So just something random that is interesting that is going on in the ecosystem. But generally, if you're considering posting ad at scale, so much so that you will come into the ambit of the Advertising Regulatory Council because they generally go on Instagram and Facebook to search for people and then they send them letters and tell them that they've infringed and so on. So what you can do is to instead focus more on inbound marketing as opposed to direct marketing. So if you say that you're doing something to educate people on a particular subject while also telling people that, at your business that you people are constantly doing X, Y, Z. So you're indirectly referring them to yourself as an expert. But if you do it directly, then they will come for you. So just something random. Okay, great. So this is a very small snapshot of myself. I am the managing partner of BlackCrest. I studied at UNN. I did my LLB at UNN. And then I went for my master's at the Nottingham Business School. And I also did a postgraduate diploma in technology at the Nigerian University of Technology and Management, which was where I started my tech journey back in 2021. So at BlackCrest, I have worked with a lot of founders, just like you said earlier. And I also am a startup mentor for VC for Africa. So they refer people to me to support their business operations. So what is IP? We've heard a lot about IP, which the full name is intellectual property. But what does it actually mean? Does anyone want to try? What is IP? Okay. I'm thinking I should point at someone since nobody wants to say anything. So intellectual property is all about the way that you're trying to protect something that you've created. So intellectual property is like what you have created, right? It could be something physical or something intangible. Generally, that's how it works, right? But when it comes to a right in law is generally something that empowers you to protect an interest that you have in something that's been created, which could be tangible, again, emphasis, tangible or intangible. Now, when it's a tangible intellectual property is when you can apply for intellectual property rights like patent. So people that created the camera, they were able to apply for a patent for the camera, right? Because you've created a process that is subject to industrial replication that creates a novelty in the way that something is being done. So for example, if you created a system that allows people to detect cancer earlier, so it's likely going to be a device that makes use of some sort of process, and then it's also likely going to be subject to industrial replication. So it can be replicated and sold to different places. So that's why you can get a patent for something like that. Are we still together or have I gone have I gone too far? Okay. I should go ahead. Okay. That's fine. So when it is non-tangible, that's when you refer to other rights like copyright, industrial design, trademark, and so on. And we're going to learn more about what each of them are and how they apply to your startup. So okay, let me just take it again. There are 5 major types of intellectual property that you should be aware of as a founder. There's copyright, there's patent, there's industrial design, there's trade secret, and there's trademark. So I'm going to take them, the key ones that you need as a founder, one after the other. Generally, patent only comes up when you're building some sort of hardware. Although in developed countries like the US, some people have been able to get patents for their software, like the Apple operating system. It has like a patent in the US. But I am not aware that there's ever been anybody in Nigeria that successfully got a patent for a software. I'm not aware. Generally, the copyright law says that software is subsumed under literary works. But I mean, you can argue that if the software is sufficiently unique or whatever, and is embedded into some hardware, that you can still claim patents. But there's been no software patent in Nigeria. Are we together? Okay, great. So the first one is copyright. So it's the right of the creator to create and reproduce for commercial benefit what he has created for himself. So I'll take that again. It's the right to reproduce, publish, and distribute your literary artistic work for your commercial benefit. So the goal is that the intellectual property right gives you the unique right to prevent other people from distributing what you have created. Because if they are distributing it, then they're likely doing that for their own commercial benefit. You get under the copyright law, there are exceptions to distribution and use. There are exceptions to that. When someone is using your work for educational purposes, for example, you can't sue them for infringing your copyright. That was the reason when we were back in university. I don't know if you remember, people used to photocopy textbooks and all of that. So the reason for that is actually because you're using it for educational purpose, right? But the people that had the photocopying machines that were making the copies and selling to students, those people are very guilty because they are distributing for commercial benefit. But the students that were making copies were only making their own copy for their own consumption. So such a use is allowed under law. Are we still together? So if, for example, an institute that is teaching tech, find some of your product designs and processes somewhere, I don't know where they will find it, but wherever they do find it, and then they are using it to teach some other people like how to do good products and so on. If you try to sue them, they will say that they were using it for educational, provided they didn't charge those students to attend the class, because then that would be commercial benefit. But if they did not charge those students to attend the class, they were just teaching them, maybe it's an NGO, you can't sue them for infringing your copyright. Are we still together? Okay. You can't sue them for infringing your copyright. So copyright covers your code, your software code. It covers all your product assets. So assuming that you are a UI UX person, so we know how we do all those things with Figma, all of that is copyright. You get the copyright in the Figma that you've created belongs to the person that created that design. Are we together? It belongs to the person that created the design. If you're a software developer, you've decided to write a new code that can rival AI, the copyright in that code base belongs to who? The person that created it. Are we still together? Okay. So for trademark, it's also a different type of intellectual property right. So trademark has to do with the symbol that is unique to each business or company, as the case may be. So when you register your trademark, it gives you the unique right to use that sign, symbol, or logo in your branding and communication materials. Now, this is very important. And it's very important because of all the intellectual properties they're going to have to deal with as a founder, this one is the one that is the most interfacing with clients or your market and so on. This one is the one that is the most interfacing with everybody. So the way that we're built as humans, we tend to associate things with things because our brain is like a pattern recognition machine. That's how we operate as human beings. So we make a lot of associations. So when there's a brand for a particular business and that brand is represented by a logo, over time people start to associate that company's logo with what they represent as a business. And again, it's not so much about the symbol itself. It's about what it represents much more than what the symbol is. Are we together? It's an emotional thing. It's not something logical. You can't rationalize it. It's just what it represents. So as a founder, if you have a logo or a mark that you want your business to be represented by, you're supposed to, assuming you want to use it exclusively, you're supposed to go and register it as a trademark. If you don't do that, you will have a scenario where somebody else, maybe even your enemy, that is not even interested in doing the business, person will create a similar logo and go and register it. And the goal is that whenever you decide to register, you won't be able to register. This happens a lot in the US. It doesn't happen a lot in Nigeria. That might mean that we're good people. I don't know, but that might mean. So when they register it, when you now want to register, they will tell you that the trademark already exists. So sometimes what those people will then do is that they will now write you a message saying that, oh, we own XYZ trademark. We found out that you're interested in registering XYZ trademark. We're happy to give it to you or sell it to you for XYZ amount. So you would now be the one to decide if you want that mark enough to pay whatever price that they're telling you. You're the one that will now get to decide. But if at the time you came up with the idea, you quickly rushed to register it, maybe you would not fall into that problem. Because again, people don't do things that they don't think would have some commercial prospects in the future. So maybe they didn't even think that the logo was relevant to register. Maybe it was after you had done some things, you had become very renowned, reputable, you have a lot of customers. So the person now knows that the logo is valuable because customers now represent, like they are now relating your competence in the industry with the logo that you represent. Now, and there are several things that somebody can do with a logo that belongs to a company that they did not register. If somebody else that is not the owner of that business registers the logo, they can use the logo and create another business that is bad and start creating negative public relations for you. Yes, they can associate the logo, for example, with maybe a betting platform when you're doing something in fintech, or they can associate it with a religious thing or a propaganda website. There are a lot of things they can do. And so over time, people will now start wondering, is this person the same person? Or is he someone else? Or is this like a part of their business, like a subsidiary? That creates a lot of damage to your reputation. It creates a lot of damage. I'm emphasizing it because so many people don't know that they should do this. Immediately they come up with the idea and they've decided on a logo that works. Here's the best part. For those of us that are worried, because you've probably not registered your here's the best part. The best part is that you can change your logo and you can change your trademark. So even if you started a business, usually when people start first, they just want to gain some traction. But as time goes on, they rebrand. We've seen that with Lemonade Finance, that is now Lemfi, right? And there are a couple of them. BlackCrest was Blackwood, and then we changed to BlackCrest. See the difference, like significant difference. Blackwood and then BlackCrest. And there are a number of them, a number of startups have also changed their names from one thing to the other after they had become a bit more renowned. So you don't have to worry too much about it. But the important thing is, if you've discovered that your trademark that you're trying to register has already been registered by someone else, it's high time you start taking steps to change it, because if you don't know what the other person is planning to do with it, especially if your business has become reputable enough for them to be able to successfully damage your reputation if they use your logo. Are we still together? So there's another intellectual property right called trade secret. So how trade secret works is that it is something unique about your business. It could be a business process. It could be a formula, which is why I put the Coca-Cola symbol over there. So one of the most contested trade secrets, or that everybody's talking about, is that of Coca-Cola. Like, what's the ingredient for the Coca-Cola drink? And apparently they said it's rumored that there's a safe somewhere in their headquarters where the ingredient of the Coca-Cola drink is, and so on and so forth. Personally, I don't agree with that. I think that Coca-Cola tastes exactly the same with all the other cola drinks out there. Again, I mean, some of you may not agree with me. That's fine. Those are watching online will probably also argue. All of you will be all right. I think that the Coca-Cola is unique because of the brand. And if you're a business scholar like I am, you would know that the reason why Coca-Cola is successful is mostly because of distribution. There are countries that have more access to Coca-Cola than clean drinking water. Go and do your research. There are countries like that have more access to Coca-Cola than drinking water. So when you have that kind of distribution, you will naturally be all over the place. They are making it look like it's because there's a special ingredient. That's why they're special, but it's not like that. I'm saying this because we're founders, so we need to know some of these facts. It's distribution. That's simply what they have. But in general, trade secret is a business process, something unique about your business that if other people were to know, right, it will mean that you've lost your competitive advantage. I'll give an example. An example is a fintech that has relationships with maybe a particular group of people that are involved in, let's say, import and export, right? So maybe the person has like a list, like an Excel sheet that contains details of a lot of importers all over Africa. And so they leverage their fintech to make payments, like fintechs that do cross-border payments, like cheaper cash, right? So because they have that relationship, So they're able to get those people to do their transactions through their platform. Now, that Excel sheet that contains the contact of those importers and exporters is a trade secret. Did we get the example? It's a trade secret because if someone else gets the list, the person might as well try to reach those people and offer better rates. And remember, business is about the numbers, it's about margin. If you offer me a better rate, like what's my loyalty to the other person? I mean, it doesn't make business sense if I can do it for 5 or 10 naira less with this other person. Doesn't make any business sense for me to retain the other person unless I have a very strong relationship with them. Are we still together? Yeah. So you need to find out what your trade secret is and guard it with your life. Because once someone else finds out or gets access to that information, they can use it and you will lose your competitive advantage. So what happens to the code post-launch? I put this here on papers because of the video that that he made earlier, talking about who owns the code, the ownership of the code after the software developer has built. So there are two things that happen, and it depends on the scenario. It depends on how the person that worked on the code was hired. Now, if it's a scenario where the person is working for a company, the software automatically belongs to them. I will tell you what the exceptions are, but just note that in general, if the person was the one that worked on it, the software belongs to them. Are we together? Very good, thank you. Now, secondly, if a scenario where it's two founders, let's say one of them is a marketing guy, is one that has contacts all over the place so he can bring in business, but the other person is a technical guy. There are founders like that, are they not? Yeah, very good. So there are founders that are technical and there are founders that are business-driven, operations and so on. So let's say the other guy that is the technical guy has built the software. Now, without those exceptions, in general, the software belongs to him. Are we together? Now, I know that some of you will argue, what if I was the one that told him the idea? What if I was the one that explained the concept? What if I was the one that even wrote the PRD? What if I did it? What if I did it? It does not matter. If he created it, it belongs to him, unless the exceptions I'm going to explain in the next slide are met. Are we together? I'm saying this thing so that you avoid unnecessary argument. Your arguments will not save you. It's not going to make any difference. It's not, because we've seen cases like that. Oh, they've come, they didn't have these things in place. Oh, I was one that told him about. It's your word against him. If you bring someone else's hearsay, your hearsay evidence is not going to make any difference to the court. You get your word against him is not going to make. They will ask, who built the code? He said, I built it. So what are you saying? I'm saying I'm the one that. Do you have any documentation that shows you're the one that? So there's no documentation. You had a gentleman conversation. It will not help you. Okay, so these are the exceptions. So when is a software developer and is working as an employee of a startup, so if the startup has given him a standard, I think I emphasize the word standard, a standard employment contract, that is the only time that such a code base will belong to the company that engaged him. And I will tell you the reason why I put the word standard there. Because a contract may not contain some relevant clauses. It does not mean that it is not a contract. Right? So I say standard because the standard is that the IP ownership clause must always be present in a contract that is given to an employee. IP ownership clause simply says that the IP in whatever this person builds shall belong to the company. It doesn't matter if they were engaged for 2 years. It doesn't matter if they were engaged for 1 year. It doesn't matter if they were engaged for 3 years. That the IP that they create in the process of this employment shall belong to the company. It shall belong to the company. And I will explain the common law principle behind that. Because again, some of us that have worked with some startups, because some of you will now have questions like, oh, what if I created the software, but it was not directly the software that they asked me to create? What if I created another one while I was working there? Right? So if you created another one and there's a contract like this, with a clause that says that the IP will belong to the company, it will still belong to them. And the common law principle goes back to the master-servant relationship that exists between an employer and an employee. Now, the reason why this common law principle evolved was because in the past, a lot of people were doing things and they were claiming that the employers were claiming that they were not responsible for those people's actions. So over time, common law is usually laws that evolve through cases, like judges sitting over cases. So the judges were now like that. If this person is the one that told this person to conduct this activity and is in their normal course of doing business, then this person should not be able to say that this person is not responsible for his action. You can't tell someone to construct a building, and in the process of constructing the building, they put a faulty pole that now allows something to fall on someone. And then the employer that contracted them is saying, no, I am not responsible. That is the person that he told to build that is responsible. The law says, no, you are responsible as long as the action is in the normal course of business. So that's the principle of the master-servant relationship. Now, drawing this down to startups, right? How it works is that because the employer is liable for what the employee does in a normal course of business, then justice also demands that whatever the employee creates in a normal course of doing business, that it should belong to the employer that is ultimately responsible for whatever activities that he conducts in a normal course of doing business. Are you aware that if an employee of a bank commits fraud that customers lose their money from, that the bank is the one responsible to repay the money? Not the employee that took the money, the bank. Are we still together? So that's the general principle. The master-servant relationship of common law is what makes this thing even possible. So as long as you are in active employment and you signed a contract that contains the IP ownership clause, as long as you created something using their resources in a normal course of doing business, it will still belong to them. It will belong to the startup. They gave you a MacBook. You use the MacBook to do Figma. The design you've done belongs to them. Even if it did not relate to what you were employed to do. Yeah, most employers will not go after you for using their PC to do other things. But I'm just telling you, that's the position of the law. I'm telling you, that is the position of the law. You use a PC that was given to you to create, content, video content, and you are hired to do video content. Even if the video content you're doing does not relate to what they employed you for, as long as you've used the company's resources to create that material, it belongs to the company. There have been cases in the US and other countries where people use resources of the employers to create another startup. And the law said that the employer had the IP in that new startup. So most times if you just want to build your own thing, just resign. So that at least whatever you're doing, it belongs to you. If you don't resign and you use any of it's not just laptop, because I've mentioned laptop, we've now zeroed our mind into even internet. Like Wi-Fi, maybe you use their Wi-Fi or you use their workspace, like you name it. Anything that can be classified as a resource of that organization that you have taken advantage of, it will still make whatever the result of your IP creation to belong to them. Now the second exception is where the software developer works as a contractor. So the first one I said was when you work as an employee of the company, right? But then employers and contractors don't have the same legal obligations. They don't. There are a lot of implications, but I won't go into all of that. What I just want you to know is that if the person is a contractor, you may not have to send them an employment agreement because they are just contractors. Maybe they'll work for a month or two. You can send them a contract. I call it engagement contract, that defines what you want them to do, defines a time frame, and what they're expected to do. But you must also include the IP ownership clause as well as confidentiality clause in that contract. So the reason for that is so that by the time they are done building, that code base will belong to you. We've had a situation where someone reached out and said that they engaged someone to build something First, they didn't have any contract, which is usually the case because people only come to lawyers when they have problem. It's not a good thing, no, but that's what happens in practice. So they said they didn't have any contract. And then we asked, okay, so what's the issue? Said that they were owing the developer. I think this is very popular with developers. They were owing him the last tranche of payment. They agreed $5,000. They had paid 4. So it was remaining the last tranche of payment, which is 1K. And they had even gone ahead to launch, use this thing on the code base to launch and all of that. They were even actively raising money. You were telling me that they were trying to get some clients so that they can now get the money to balance the developer. They were not communicating. They ghosted the guy for 6 months. Then I said they woke up one day and they couldn't access the database again. Apparently, the guy locked them out of, because the guy had been sending emails, calling and texting, and they did not reply. They didn't say, oh, we're so sorry for the delay. They didn't say any of that. They just ignored him. Almost like they did not intend to pay him. And then the guy took the database offline. He took it offline. I think he even went as far as posting on their website that this person is owing the developer. People say they're owing the developer. So they were now like, oh, that the IP belongs to them, that they want us to go after the guy. I'm like, do you have a contract with him? No. The IP belongs to him. I'm sure that the guy doesn't even know that the IP belongs to him. He's probably just acting out of frustration. So he's holding the platform on lien until he gets his balance. He doesn't actually know that the IP itself even belongs to him because there was no contract. There was no contract. So if they were to sue that chap, the law would not only say that they should pay him his balance, but the law would say that he can even claim ownership of the IP. Can claim ownership of the IP, although they will not argue that, oh, that they paid money, that it creates an implied contract, blah, blah, blah. But that will even still be something that will be contested. So having your documentation clearly saves you a lot of the stress. Then the third scenario is where the founder signs a standard founders agreement. So usually when founders start working together, they are two friends, met at university, and they've been friends for a very long time, maybe 5 years or 6 years, started building something. Nobody really bothers about any type of contract. It happens all the time. And then this other guy is now seeing like a potential area where he could explore the idea even further. But he doesn't want the other person to come along with him on the new aspect he wants to explore. And he's like, I built the code base. I wrote the code. I came up with all this. And then he's like, I'm leaving the team and I'm taking my code base to go build something else. And then the other person starts to cry foul. But we were doing this thing together. I'm the one that's been doing marketing, brought the first set of clients and all that and all that. So it usually leads to conflict, can get very messy between two co-founders. But the reality is that if the two of them never agree that the IP ownership should go to the company, it means that they both have like their own separate intellectual properties in the different things that they're creating. So the one that is creating product, requirement documents, creating marketing processes, all those intellectual properties, they all belong to him. And the one that created the code base also belongs to that one. So it creates like a challenge in administration in the event that a founder wants to leave. Which is why this is an exception. If the founders have signed a standard founders agreement, which is why I use the word again, standard, usually there's an ownership of intellectual property clause in a founders agreement. So that says that the intellectual property will belong to the company. Assuming the company has not been created yet, it will say that it will belong to the company that is incorporated by both founders in the due course of doing business. And as long as they've incorporated that company, that agreement, this founders agreement will bound them to not be able to take any of the IP when they're leaving. Whatever issue you would have would relate more to shares, that maybe you're saying that, oh, you want to leave, they should buy you out, or that you want to sell your share to someone else, maybe a third party, something like that. But you can't say that I'm taking the IP when you've signed a founders agreement that is standard. You can't say that. You can't. And in fact, there is no angel investor or institutional investor that is worth their salt that would agree to invest if they don't know that you and your team, you and your co-founder have a founders agreement. They will not agree. Because they want to be sure. So what if somebody wants to leave? So my money that I've invested, $100,000 will disappear because the other person runs away with the IP. So they don't want those type of issues. So that's why I'm spending time to explain it so that we understand. Once there's nothing like this, it means that it's a free for all. I'm the one that created the database for new customers. As I'm going, maybe I'm going to work for another company. I'm going with my clients. You can't do anything about it. You never signed that it does not belong to you. You can't do anything about it. So if you're currently operating like that, just know that if anybody decides to leave, you can't stop them from leaving with your IP. So how can startups protect their intellectual property? So this is a part where we now start going into all those steps and processes that you can use to ensure that you don't fall into these challenges. So the first one is by incorporation. This should be a no-brainer from everything I've been explaining, right? So if you incorporate, naturally that IP that you've agreed with your co-founder should belong to the company, will automatically belong to the company. Now, why it's so important is because the company is like a legal entity. So human beings are also legal entities on their own. So I can be sued and sued in my own name, right? I can own property. So these are like qualities of a legal entity. I can own properties, I can vote and things like that. So a company can also be sued and sue in its own name because it's a legal entity, right? It can own properties, can own a bank account, and so on. Are we together? It can even enter into contract with someone else, just like a normal person can enter into contract with someone else. Are we still together? So in law, that's called legal personality. So a company has legal personality. So one of the best ways to protect your intellectual property is to have a company. Incorporate your business. Have a company. So once you have a company, there are other things that naturally follow. There are governance processes. Usually you have a board of directors that will be saying, okay, so we own XYZ assets. So we need to ensure that we streamline all those assets so that we don't have any issues in the future. So usually when you have a company, it means that more than one person is now involved. Although in Nigeria, you can have a small company. But usually if you want to build a startup, you can't have like just a small private company because you need other co-founders or other stakeholders, directors, advisors, and so on and so forth. Are we together? Are we still together? Okay. So the next one is by signing a co-founders agreement. The founders agreement, I explained some of that earlier. So when you sign it, you include a transfer of IP clause or ownership of IP clause. So you can say that you will transfer after the company is incorporated, or you can say that the ownership is with the company that's already been incorporated. So those are the two things you can do. And there are other things you can even do. You can even include a bad leaver clause. Like if somebody wants to leave and they're leaving on the grounds of things like serious misconduct, maybe they defrauded the company, or maybe they made secret profit. Some people can leverage their position in the company to make secret profit from other places without disclosing to their partners. So if it is discovered, that is still gross misconduct because you're not acting in the interest of the business, even though you're one of the owners of the business. I wish you together. So the things that constitute gross misconduct could even include sexual misconduct, harassing team members and things like that. So they are all part of things that can be considered as gross misconduct. So once those criteria are met, the bad leaver clause, which you might decide to include, can say that the person would lose whatever share of intellectual property they have in the startup. Are we together? But only if they left under those conditions. Because someone can decide to leave because they don't want to be part of the business again. That doesn't make them a bad leaver. Are we together? But someone that is leaving because he has been found to have fraudulently used some funds of the company to do what he's not supposed to do, then that means that if you want the person to leave, you can put a clause that says that they won't have any of the intellectual property. You may not be able to say that they won't have their shares. It will be difficult. They will not agree to sign it, right? But you can say that, maybe they will only take half of the value of their shares. Because once their gross misconduct becomes public, the brand will take a hit, and that affects the valuation of the business as a whole. If you want, you can do further studies on equity, like brand equity. It's like a concept. When you have significant brand presence, it increases your market value as a company. And if something happens to the brand, in terms of like people now associating something negative with the brand as opposed to what they used to associate, it can affect your ability to price, can affect your market position, it can affect a lot of things. It can actually affect a lot of things. There was a time that Coca-Cola had such a problem. They created a batch of Coca-Cola products and people were complaining everywhere. And the CEO had to come out and say that, they tried to create a new set of Coca-Cola, that they are recalling all of them, and that they will continue with the previous ones they've been doing. It was a thing, like back in the early 90s. It was actually a very big deal back then. So you can also read up about it to see how things like that can affect a business. So the other one is that you should issue an engagement or employment contract. I've already touched on some of these things in our previous conversation. So you need to ensure that if the person is a contract staff, that the contract is an engagement contract. If the person is an employee, then it should be an employment contract. Now, I will tell you one of the legal implications of sending an employment contract to someone that is just a contractor. The major legal implication is that the person would now be entitled to the benefits that employees are entitled to under law. What are some of those benefits? Health insurance, pension contribution. Why are we looking surprised? We don't know that employees are entitled to health insurance. Yeah. The law says that. Sorry? No, let me clarify. I said if you send an employment contract to a contract staff, they will automatically now become entitled to the benefit of a normal employee. Yes, you should always have a separate contract that you give to your employees and a separate contract for contract staff. Yeah, and again, pension contribution only happens or you have the obligation after you've exceeded at least 15 people. So if you don't have up to 15 members on your team, you may not necessarily have the obligation to start contributing to pension yet. So that's also something to take note of. But the idea is that I do not know how many people you have on your team. But I'm just saying in general, if you send an employment contract, someone that is a contract staff, those benefits that are meant for just employees, they'll also be entitled under law. They'll be entitled under law. They can always take you to the National Industrial Court to find out what the judges think about it. So remember to tell the lawyer to include a confidentiality clause, no matter what type of employee the person is. Because that someone is not stealing the IP does not mean that they can't tell somebody else some ideas about the way you're building your IP that they can use against you in the market. So that confidentiality is very key. It's very key, especially for people that are not full-time team members, especially for those ones. You don't want someone, you're discussing something with them, maybe you have a new idea of how to send money to other countries, like cross-border transfers. Maybe you have a new approach to doing it, and you now brought in the person to build something. If you don't put a confidentiality clause, even though you own the IP, you're not stopping him from telling someone else what he's doing. I don't know if what I'm saying makes sense. It's like a legal loophole. The fact that you say that the IP belongs to you does not mean that it automatically means that he should not talk about it. You also have to say that he cannot talk about anything that he's working on. If you don't do that, he will have the right in law to discuss it without consequence. Are we still together? Okay, fair enough. So you have to register and secure key IP assets. So the key IP assets, we've discussed them initially. For the trade secret, you're talking about your business processes, right? And then for trademark, we're talking about the mark, the logo, or the slogan that you want to use, right? Okay, very good. So now, the goal is that the ones that you cannot do without registering them, things like the trademark, you have to do those ones as soon as you can because it helps you to protect your right to use that logo so that you can build your brand effectively. But for the other ones, like the trade secret and all that, It usually comes up when you're trying to do partnerships. Someone comes in and is like, oh yeah, we've seen what you're doing. We think we could collaborate, all those type of things. So they're sending you MOUs up and down. If you don't include the confidentiality clause, because that's the way that you protect your trade secret so that people don't talk about it, right? If you don't include it, it means that every single time you have a potential partnership with someone else, that they now know everything about your business and that they can potentially also tell someone else that can use it against you. And then also try not to discuss things that are very fundamental to your business process. Try not to discuss it in general. You're trying to do a partnership. Yes, they're saying they want to know your capability. They might also be fishing to understand your process. You can just simply tell them that, yeah, we've done this with this person, we've done this with this person. But don't go into details about like how exactly you did it. Right? For example, instead of saying that you have a list of importers, for example, you can say that you have contacts in different places. That's vague. Are we together? You can say I have contacts in different places. Everybody has contacts in different places. It doesn't really say anything about how exactly. You can say that you have proprietary infrastructure that can make the process smoother. You're not necessarily saying anything. You're simply saying that it's proprietary and there's an infrastructure. You're not saying how. So we have to be very careful with our words, especially if we do a lot of communications over emails, because they can always go back and read, right? And it's very difficult. I don't know if anybody has ever tried it. It's extremely difficult to recall an email if the person is not internal. Extremely difficult. Extremely difficult. Please do not mistakenly attach your product process to someone because you're trying to do a partnership. That would be a nightmare. And do not let interns have access to your code base, irrespective of how competent they are. Mostly because of an experience that one of our clients had. There was a time when their code base was put online. Online. We put it online for like 24 hours. And they were calling us 247, like, what's going on? What's going on? And at the end of the day, we found out that it was a disgruntled intern that now put the database online. So the problem is not the skill and competence. It's about emotional regulation. And sometimes, again, people are going to fight me for saying this, but I feel like people that are younger don't have as much emotional regulation as people that are older and more experienced. That is my opinion. That's my opinion. The boy was just 18 or 19 years. Put the entire database online. So that what will happen? So that what will happen exactly? You get, and I mean they let him go, obviously. They would have taken other measures. But I mean, the boy is young. Probably didn't know the implication of what he did. Probably just felt like, I'm not happy. Doesn't know that could affect their competitiveness. So that's also another thing. When people are not grounded enough to understand the implication of certain things, the tendency to just do things and just feel like I was not happy is very high. Are we still together? So if it's a patent, also endeavor to register it as soon as possible. There was a chap that reached out to us sometime in the past. He was trying to register a coconut opening platform, like a machinery, some kind of mechanical contrivance that could open coconuts and process the back and all that. He eventually got the patent for that. So if you have hardware like that, even if it's a tech-related hardware, you could also consider applying for patent. Don't wait. Once you've come up with the idea and the process works, just start trying to apply for the patents. Don't wait. Because if you wait, someone else somewhere else might also come up with a similar idea and apply before you. So this is the last one. You need to monitor your assets. You need to continuously monitor the assets that you've created. So if you have IP, it's not enough to have lots of IP. Because as a startup, as you keep growing, you keep having more intellectual property. It's either you're increasing your product process, like let's say you have a playbook. You've got a playbook for Ghana, you've got a playbook for Kenya because you've moved to other countries, right? That's trade secret, yeah? How we engage with vendors in Kenya, what are the challenges, and how we've been able to overcome those challenges is a trade secret. Because your competitors probably don't know that, right? You have to send some of your guys over there to learn the hard way. So you probably know, but they don't know. right? So maybe when you become like Otedola, then you can write a book on making it big. Then you can talk about those ones 20, 30 years after you've done it. But while you're still in the grind, actively building your startup, you should always ensure that you're constantly monitoring all the assets, the intellectual property assets. And first is that there's a single place where you can find all of them, because it's very easy, makes it easy for due diligence when you have an investor that's interested in investing. If they can see that all your intellectual properties are in a single place or in a single folder, it shows that you're committed to actually constantly monitor to see how you can better protect the company's interest. Are we still together? Did I lose anybody? Okay, that's fine. So the idea is that if they know that you're that coordinated, it also gives them the impression that you know what you're doing. It gives them that impression. That's why it's very important. And you should also be able to anticipate potential new intellectual property that your team might create based on your trajectory. That's why I said continuous monitoring. That's why I said continuous. Okay, we have one product. We are planning to launch a different product. That different product would likely have a different logo. So we're already planning to ensure that we also trademark that logo so that someone else does not use the same symbol that we're using for our product. So it's more like if we already know we've planned it this year, we're planning to launch by next year, we're already making the plans to also secure and register that intellectual property. Are we together? So it's not enough to just have. You have to envisage what you might still create and then figure out a way to ensure that all of them are well protected. You're speaking to an investor, they're saying they don't like signing NDAs. Sorry, please insist. Because you don't know if they have someone in their portfolio that is doing something similar. So they just want to talk to you so they can give the person ideas. It's possible. You don't know. It's very possible. They can even say, we want to record the call, so that we can listen again to make our investment decision. They can tell you a lot of things. But yeah, after you've told them, this is how we're building it, this is the process, these are the customer base, they just take that recording and send it to the other people in their portfolio. Always get the investors to sign the NDA where possible, especially if what is at stake is significant. First-time founder, valuation up to $1 million, probably don't bother. But if second, third-time founder, you've got like products that are already making money, that have customers, you're doing numbers, definitely insist that they sign the NDA. Definitely insist. Insist, because there's so much that you're going to have to explain to convince them to invest that it's not possible that they won't take away some of that to potentially affect your interest, especially if they are choosing not to invest. Are we still together? All right, so some of the common challenges that founders have. I'm wrapping up. I'm already getting the signal. Some of the challenges that founders face in general is they're not clear about the intellectual property ownership. But I'm sure that after this session and everything we've explained, that we are now clear who owns what and the exceptions where the person may not own it. The general rule is always whoever creates it is the owner, unless there are contracts in place that say that I am surrendering my rights to own this item to the business or to the venture, as the case may be. Or I am an employee and I have agreed to surrender my rights to the ownership of anything I create while in employment of this team. Are we still together? So that's the first one. Second one is poor documentation and record keeping. We've had a client that someone wanted to give them a small check, I think 50K, and then they were saying that they didn't know where their trademark was. They had applied. They had gotten it, but they didn't know where it was. It sounds funny, but it's a real issue. So you're like, there was one lawyer somewhere in Akwa Ibom some 3 years back that did the trademark. So where is it? I think there was one email that he sent it to. I can't remember. It happens. Please don't be like such a person, because it will make you look very unserious. Building a tech startup in Africa is a serious business. You can't afford to be doing it like something pedestrian. You need to be organized. You need to think through what the potential stakeholders are looking to, like what they expect, the type of standard of governance they expect from you. So having good record keeping of all the intellectual properties, as well as having clear documentation of all of them, is important. Very, very important. Both the ones that are registered and the ones that are covered by contract. Are we together? So the third one is always non-existent founder agreement. I've seen so many founders that don't have any founders agreement. And the funny thing is that they will be at the stage where they're trying to raise 500K from one investor like that. I've seen a lot of them. And they're like, oh yeah, we're just drafting our founders agreement now. So again, you can be lucky. I've seen a lot of founders that were also lucky. So you can be lucky and you and your co-founder, you don't have any issues, you're building together, so you're not at the point where you want to raise. So it's just even a formality. But there are people that are not so lucky. They're not so lucky because by the time they are ready to then take that next step, what happens is that they find out that the other co-founder does not want certain things, or that the other co-founder never had their interest in mind. So what then happens is that conflict starts. And once conflict starts, the chances that the business will disappear is almost 70%. One of the reasons for that is not even because of what you're building. What you're building can be fine. But it's the idea that I slaved for this for 4 years for someone else to push me out or to benefit without me getting an equivalent amount of benefit. It's our human sense of injustice. As long as there's an injustice involved, the chances that the business will succeed is very low. Because it's more like, there's an Igbo saying that instead of allowing it to work, let's scatter it. They say it in Igbo language. I don't want to say it here. But it's like, yeah, that's something that we say in the East. So that's the mindset that comes up, that this person doesn't want me to get my benefit. I've worked so hard for this. This person is now claiming that I'm not one of the rightful owners. So therefore, I am going to do things that will make it impossible for the business to succeed. Maybe the business thinks that it can do it without me. So let me show them that without me, the business will disappear. So that's what usually happens. So please try as much as possible to put together a founders agreement as soon as possible. If you're already working with someone for a long time and the two of you now want to go ahead and keep building together. Sometimes people are afraid. What if I start working with this person and the relationship is not working out? It's a valid concern. So what we usually advise founders is to include a trial clause where it's like a 6 months or a 1 year. If we're both not happy with the way things are going, we can both go our separate ways. So you can put a trial clause. And then you can now agree on commercials. If you've contributed and I want to keep doing the business, maybe I will settle you for whatever you contributed. But the idea is we're not tied together simply because we decided to do it together. So that's like a way to go around that fear and uncertainty of how the person might end up behaving. Are we still together? So there's weak employment or contractor agreement. So when it's weak is when it doesn't include those relevant clauses. That's why when I said it earlier, I said standard agreement. If you don't include an ownership of IP clause, confidentiality, and non-compete, you are shooting yourself on the leg. We've had a scenario, I don't want to mention the name of the startup, but we've had a scenario where a top startup poached some top guys that were working somewhere else. And guess what? That top startup did not have non-compete in the contracts they gave those guys to sign. Like anytime I remember that, I'm always wondering, who was the lawyer that drafted? I'm always wondering, who was the lawyer that drafted those things? They didn't have. Those guys went to their competitor and gave them significant advantage simply because there was no non-compete clause. So when you're looking for a lawyer to work with, try to work with lawyers that are conversant in the industry, that have been doing it for a long time, for clients that are successful as well. Because mistakes like that, even though they are small, they have significant impact for businesses. Imagine someone that you've trained for 6 years, you've sent them to different countries for training, you show them the entire business process, they are abreast of all the trade secrets, and then someone else just offers them maybe 5 times what you're paying because they've raised money. The person now leaves, but that's not the problem. The person leaves and doesn't have the obligation not to disclose what they have learned. What are you going to do? And not just 1, 2 or 3 top guys in operations and so on. 2 or 3. So what do you do? So it's a significant setback, and it can be avoided by just ensuring that you have the right contracts from the beginning. So the last one I'm going to mention is scaling too early. That you've raised money does not mean it is time to scale. It does not mean it's time to scale. That you've raised money does not mean that you now have the structure that can support the type of growth that you're looking for. It really doesn't mean that. In fact, you can even shoot yourself to the grave very quickly by behaving in that manner. There's a popular adage that says that if you want to go fast, go alone. If you want to go far, go as a group. So it also applies to scaling. If you want to go far, like you want your startup to still be a going concern in the next 5 years, your first fundamental thing is to figure out, okay, what is the foundation that we're currently operating on? The foundation is different facets. There's a business foundation, there's a people foundation, there's a compliance foundation. There are different things. But you need to focus on how strong is our foundation. Once that foundation is strong, then you can build a 5-story on the foundation. But the foundation is not strong. If you build 3 stories, 4 stories, what do you think will happen? It will collapse. It's inevitable. It will collapse. A foundation of people management that doesn't include non-compete over a period of 2 years can rob you of up to half of your market share if your top guys are leaving. Yes. If your top guys are leaving, they're leaving with all the experience. Because there's also organizational memory. So you, the CEO, you can't do everything by yourself. You're out there raising money. You're there telling the story of what your startup is doing, supporting people. So you want your people on ground to be doing the groundwork. So your people on ground are leaving because there's someone else that's raised money, bigger cash than you have, and they're willing to pay higher. Then what that means is that they will simply leave with all your business process and go and give it to them. As they will even use it to leverage to get a higher salary because you did not stop them from doing that in the first place. There is a popular case. This one is actually online. There's a popular case about someone that left. I don't want to mention the name of the startup, but someone left the employment and then he went to work somewhere else that was also in a related industry. So they took the person to court. They were like, no, that this person has a lot of our trade secrets. This person works very closely with us. He can't be working in the same industry. Guess what? The court said, that's the Court of Appeal. The Court of Appeal said that the person's fundamental right to economic determination, which says that they can work and live wherever they like, is under the social objectives part of the Constitution, that it allows them the right to work in any country whatsoever that they desire. The Federal Consumer Protection Law that even gave that thing as an exception, where you include a covenant that prevents the person from working somewhere else, which is a non-compete. The court still insisted that the fundamental human right was in the Constitution, which is a higher law than that one. And so therefore, that you can work there, which means that your non-compete may still not even save you. Now imagine if you don't even have one. Now imagine if you don't even have one. Do you get? So the regulatory space is getting very interesting. Very, very interesting. But what we can do is to try to protect ourselves as much as we can from those type of things happening. Of course, there are things you can do to also ensure that your people stay. But I think that's something that Chingozi might invite someone else to talk about on a separate day. But yeah. So thank you all so much for listening. These are my recommendations. You should get clarity. You should get clarity on the IP assets that you're dealing with. Second one is that you should register all the ones that you cannot do without. Things like trademark, I beg you, register it on time. If it's patent, register it on time. For copyright, generally, do not put any of your copyright in a Nigerian database. And I'm not going to say why, but I'm not sure that it's such a good idea. You're better off having your own servers on Amazon or OneDrive containing all your intellectual property, copyright assets than going to register it somewhere that you do not know if they can easily hack their system and collect what they can collect. So then lastly, involve startup lawyers as much as you can, especially for employment and partnership documentations. People always assume that it's not just template. I've even seen ChatGPT, ChatGPT copies. But the funny thing about all of this is that one is that OpenAI have updated their policies. They're now saying they're not responsible for whatever the AI says about medical law and other professional organizations, like professional type of fields that is giving advisory. They are saying that if you rely on it and it's bad, we're not responsible. I know you guys did not know that, but I'm telling you now so that you know. That's one. And then two is that the contracts that these things generate do not always account for the specific laws of the places that you're trying to use it for. And the reason for that is that the laws are too much. The laws are too many, and the cases are constantly changing the positions. So it's very difficult for the AI to even catch up as such. And then there's the third one is context. There are some things that you might want to do, and someone will tell you to leave it. And the person telling you to leave is telling you from experience, from other people that he has worked with that tried to do it, and it backfired. But you will not know that unless you ask someone that has context, which is the point, right? You will not know. So thank you all so much. I think I'm open for the questions now.
Yeah. Okay, so I think we can take a few questions. Anyone who already has... okay, let's... All right.
Okay. Thank you for this presentation. I have like 2 or 3 questions.
Okay.
The first one is open source.
Yeah.
Where does open source code fall into all this category? I don't know. I just want you to clarify. Secondly, there was an SLA I once worked with, and it extends beyond the service. For example, even after, after working with the company, like for a year or 2, you can't. So what is that in the context of the Nigerian law? And then lastly, the non-compete, please, I want you to clarify on that.
Okay.
Yeah, I didn't really catch the, the nuance of it. So thank you.
Okay, I think there are 3 questions in one. The first one is regarding open source, okay. The non-compete and... Okay, SLA, okay. So for open source, the question that he asked, I hope we all heard this question. So generally, the way open source works is that the code don't belong to anyone in particular. So they use a principle called Creative Commons, where people, they could be researchers or experts, decide to put something out for the general public consumption. And then when it's put out there, they are saying you can use it as you like. We're not exercising our copyright to the material. So it's also like that. And the reason for that is that it encourages, peer-to-peer learning as well as engagement of a lot of people towards something, which was why Elon Musk tried to make Twitter open source. I think he did. Did he do that eventually? He said he was going to do that. So one of the reasons is that when you do something like that, you can get input from everybody as opposed to just a few people. So that's the principle behind it. So the intellectual property generally will not belong to anybody in particular when something like that has been done. No, nobody can. Nobody can. So that's one. And then for the non-compete, the SLA, let me answer that one first. So if someone says that your confidentiality will extend for a year or 2 after the contract has expired, if you like, you can negotiate it and say that you want it to only extend for a year. You can actually negotiate such terms. But if you don't negotiate it and you sign the contract, you're actually bound by the contract. It's under the principle of privity of contract that the parties are bound to what they agree. So if you agreed, then why are you changing your position? Because the other person can claim that the only reason why I accepted to work with you was that that part was also part of the consideration. So if I've already given my own consideration, which is the money I paid you for the service, then you're reneging on the contract by not following what we agreed that you were going to follow. So if you've agreed, then you're bound by it. But if you did not agree or you try to negotiate, you might get a better term. Then for non-compete, so in general, non-compete means that you don't want the person, when he leaves your employment, to create a competing business. So that's like the general concept. You don't want them to create a competing business or to go work for a competitor. And the reason for that is that your competitor already has what their own unique advantages are. And your people are a significant part of your own advantage. In fact, I believe that the people are the most significant advantage any organization has everywhere in the world. The people are the most significant advantage. So if one person leaves, it means that he knows a lot about how your own organization operates. So if he's going to work for your competitor, there's an almost 80% chance that he will also share or implement some of the things that you're doing at your own company there as well. So, and if he does that, it means that the competitor now also has your advantage. So putting a clause that says that you do not want this person to compete with you after they've left your organization for a period of time is simply to protect yourself from someone giving your competitors more advantage against your company's interest. So that's why. So usually some people put 1 year, some people put 2 years, but it depends. There's no widely accepted standard. Usually it's negotiated. Yeah, usually it's negotiated. Please go ahead.
All right. Good afternoon. I have two questions, and both are based on jurisdiction. So the first question here is,
Thank you.
okay, can I go ahead?
Yeah, go ahead.
All right. So my first question is trademark global? So if I trademark my logo here in Nigeria, right, can someone else, use that kind of maybe logo or something that could be trademarked outside of Nigeria? The reason being that we are trying to trademark a logo for a new product that we just launched. So we are concerned that if we want that product to be based in the UK, right? So we are trying to trademark it in the UK, but we want to sell it here in Nigeria, right? So if we trademark it in the UK, can someone from Nigeria also go ahead and do the same thing and trademark the product?
So I'll answer that one quickly before you get to your next one. No, the trademark is not global. So we have the World Intellectual Property Organization called WIPO. So they have like their own process. If you want to have a global IP, I think it costs around $5,000 or $6,000. Then you have the global IP. But if you don't do that, if you do it in a specific country, to apply to just that country. Some country like the EU, I think they have their regional arrangements where one trademark would cover the entire EU. So, but that's their own arrangement. If you register in the UK, for example, it will not cover Nigeria. Someone in Nigeria can register the same thing. If you register in Nigeria and you don't register in the UK, someone in the UK can also still register the same thing.
So that means you have to register in both
In
countries.
both places, yes.
Okay, thank you. And the second question, if I contracted someone outside of Nigeria to also build and develop a software for me, what kind of contract can I sign with the person? And even if I sign a contract with the person and this person decide not to abide by the contract, what's the legal process of, sorting that out? I don't know if you get my point.
Like can you repeat that? If you sign a contract with someone?
Yes, if I engage someone maybe to develop a software for me outside of the country, like, you hire an Indian, for instance, to build a software for you. And then what kind of agreements can I have with such a person so that the person is not going to I will pay the person, develop the code, and then the person says, okay, you are no longer the owner of this code. I will take this code for myself. And I also lose my money. Right. So what kind of arrangements can I have, legal arrangements can I have with this person to ensure that that kind of scenario does not, come up?
So usually for people that want to deal with people in other countries, my advice is always to go through a verifiable third party. So usually if there's someone more like a broker that knows all those people, because they are also in that country, so they have a way of reaching those people in the event that they're behaving in a funny manner. But if you interact directly, Nigerian laws don't apply in India. They don't apply in India. And if you use Indian laws, then it means that you yourself are willing to go to India to start trying to enforce in the event of a breach. Do you get? So what I would advise is to work with reputable organizations or reputable third parties that are the ones that are referring you to those people, so that way anything that person is doing, the reputation risk falls on that verifiable third party that should have a large enough reputation that they are not willing to risk their reputation for those type of things. So once that thing comes up, usually what some of them will do is to even pay you, and then they will then go after the other person just so that their reputation will be intact, because they don't want to be hearing that, oh, they're online on Twitter talking about something because of $2,000. Doesn't make sense, right? So that's what I would advise. In a situation where you've already done it with them, you can try to see if you can have a peaceful communication with the person, especially if you've paid them the full amount that you're owing, so that they can give you your code base. But if you use Nigerian laws don't apply in India. unless there's a reciprocal judgment enforcement procedure, of which you will still have to go to the court first, get the judgment before you now start trying to. It just feels like a lot of hassle, to be fair.
Hi, thank you. My question is concerning trade secrets. Please correct me if I'm wrong. I thought I saw on the slide it's not covered by Nigerian law.
No, it is not, because trade secrets are generally commercial, like a commercial right, as opposed to a legal right. So we don't have a law in Nigeria that says, oh, your trade secret shall be protected. No, but we have for trademark, we have for patent, we also have for industrial design. Industrial design for people that make things like this, like all this type of print. So that's industrial design. So we have laws specifically that protect those rights. But a trade secret is something that affects your business. It's like something so significant that if someone else knew about it, you could potentially lose your competitive advantage. So how you protect that is by ensuring that whoever you're dealing with is signing the NDAs or confidentiality clauses, that you ensure that the ownership of the IP will always belong to you and your team members whenever you're interfacing on something that relates to something you're building.
Yeah, thank you so much. So I just want to quickly, before I ask them, for startup lawyers, because that's also one of the issues. Sorry, I want to see him when I'm asking. So I want to be sure about, because I discovered that there was a kind of lawyer we engaged initially.
Okay.
The person is like a civil lawyer, right? Or something. So he needs to learn, but he's a lawyer apart from being a startup lawyer.
I get that,
So he needs to begin to learn, some of the tech know-hows before he can even begin to play. Though he has the basic and foundational insights about it. But we discovered, based on what you are saying now, I discovered that there's a lot of loopholes that we've had because of some of the things you are saying now. So that means that there's a clear distinct between just a lawyer and a startup lawyer. Right?
Yeah, so it's specialization. Like people have different specializations. So oftentimes people that are always saying we can do everything are litigation lawyers. So litigation lawyers are the ones that go to court, contest a claim on behalf of clients. So they tend to take up cases from different places, right? But the challenge is that when you're a commercial lawyer, because that's the category that startup lawyers fall under, the way that you're thinking about the laws is not just about, an adversarial point of view of how you can take something to court to get something for your client, but you're thinking of the commercial exigency of the client, what are their commercial priorities, and how you can resolve cases without escalating it because of brand management. So it means that in general, commercial lawyers have more more market awareness, commercial awareness than people that are not. It influences the way they think about laws, the way they engage with clients, and the way they think about how to support the interests of their clients. Yeah. So yeah, they are different. It's specializations.
Thank you so much. And you mentioned about class 45.
Yeah, there are 45 classes.
I was even thinking, so it's general. What we have, if we check for the 45 is also the same thing.
Yeah,
now,
it is.
The issue of, I think I want to remember that, I think number 38 or so, where it puts the tech, science, something.
Okay.
Where mostly
most tech platforms
using. However, if you are bringing a product that is relating to also a class 36, not necessarily, for example, in class, I've forgotten
there's a list.
So yeah,
list.
Now that means that you need to do for one, then you now go again and reclass for another one.
That is the implication.
That means if you want it to be almost, because if you have, I'm asking this question, I'm trying to ask that, is it possible that you have already appropriated for class 38? Now, did someone use another logo, another name, trademark for another class? I don't know if you get what I'm saying.
Are you saying the same person or someone different?
Someone different. A different company, probably, coincidentally have the same name or the same logo type. Can they also classify with some maybe for class 2?
Some other class.
Yeah.
Well, yes, but so remember that the way laws work is that where your right stops is where the right of the other person begins. So if you registered in class 36 or 38, for example, you can't stop someone from registering in class 35 now. If the only way you can stop them is by also registering in class 35. So yeah, most very significant startup companies, what they do is they register in all of them.
Everything.
That's what most of them do. Register in all of them. So it protects you from any super stories going forward. But what some people do that don't have that kind of budget yet is that they try to start with the first one. Then as time goes on, they reach out the second one and then the third one, at least all the ones that relate or touch on some areas that are related to their areas of operation.
Awesome. And the last one is regarding incorporation, the CAC,
Yeah.
and also now the CAC, that's the entity itself, right? Is separated from the product, right? Like you can have a product. What I'm saying is because there's a company that is kind of pushing two different products. It's
Yeah,
working on two
definitely.
different products.
Definitely.
So you need to. So can we also
Trademark.
the company? Maybe the company itself has the entity has its own logo, has its own
Yeah,
name,
sure,
separate from the
definitely.
product and all those.
Yeah, definitely you can.
And
There is no restriction. To
last
that, you
question:
can.
how can we get where do tech lawyers? Where are they? How? Yeah, I think that's the next question I need to ask.
Well, I mean, to give a short answer, I am a startup lawyer, obviously. But I think that if you are to go online on Instagram, there are a number of them posting some helpful videos and tips. And then on LinkedIn as well, you can find a number of them posting things about startups and supporting. So you generally, even just a quick search on Google about some startup law firms in Nigeria can give you some perspective on who and who is contributing, right? But the only thing you should know is that sometimes people pay for SEO. Doesn't mean that they know what they're doing. They pay for SEO and they rank, yeah? But if you ask anybody that's in startup space that's been around for a while, or what are some startup firms or some startup lawyers that you might recommend, they will tell you names that could be familiar or may not be. Then you can then go and research the names directly. So personally, I would advise you to look at the name of the individual involved rather than the name of the law firm itself.
Okay, thank you very much. My question is regarding non-compete.
Okay.
So let's say a client reached out to a freelancer, and the freelancer offers services to that for that client. And at the end of the day, the client is telling the freelancer that, okay, I'm giving you a document to sign a non-compete, that for the next 2 years, you can't do something like this for anybody. Because that's my question. That's right.
Yeah, we've had a scenario like that where that wasn't even just the issue. The person even went as far as saying that they can't use their templates for anybody else and whatever. And we had to respond to the person that in the normal course of business, you can't tell someone that they can't use like some key elements of a database like that, help with structure. But that the unique things about your own platform, maybe your code, your color code and all those type of things, that they can be for you, but you can't tell them that the general things in the template that will make it easy for them to just pull and use for a different project, that the person can't use it, right? But for that, I think you should always negotiate, push back. Saying that you might be able to build something for someone similar for 2 years is a very long time. Maybe 6 months, right? Because, like I said, you're a freelancer, maybe 6 months, but not even up to a year. I think you should push back on things like that. And usually, if you're the one responding, let me just tell you, Nigeria is very classist. Again, some people will fight me for saying this. So if you're responding to someone that sent you a contract, they may feel like, it's not just this freelancer and all of that. But if you tell them that, and if you send your lawyer, and your lawyer's right to say that, we are the solicitors of XYZ, right? The first thing the person will do is to go and check the law firm online to know if they are anybody relevant. So that's the first thing they will do. So once they've checked and they've seen, okay, it looks like these people know what they're doing, they will now come back and they will respond like people that actually have sense. So that's how that's how it usually works, right? So sometimes it's helpful. It doesn't mean that you have to find a law firm if you're still figuring things. You can find just a friend that is a lawyer that has maybe a law practice by the side. But the important thing is that we are the solicitors of XYZ. We saw the contract you sent to our client, and this is our position on some of the clauses that are in contention. So that way the person knows that, okay, this person actually has a lawyer, this person is organized enough to have a lawyer. So it means that if they are saying that they want 6 months instead of 1 year, that they also have processes that ensure that they don't endanger the IP of the other person.
I think you missed something important about the question. He said after the project was done, right?
Okay, not still why the conversation is still ongoing. If the project has already been done, it means you signed the contract now.
The contract came up after the project
No,
was done.
no, you're not. No, no, no. Please, in general, the law does not apply retrospectively. Like if someone commits what is supposed to be a crime by 2026, if you committed it this year, the law cannot go back to 2025 to apply. It does not work like that. If you've already concluded the project, even if they bring their contract, you can ignore them. They should take it anywhere they want to take it. You can ignore them. You're not bound by something that was not in the agreement at the time you did the work. It's not going to apply retrospectively.
There was no agreement.
Yeah, there was no agreement. They can't force you to sign something that would limit your own rights when it was not brought up as a consideration at the time the contract was. No, now they can't bring it up again. It's gone.
All right. We are a tech company. Now, we actually didn't have any IP agreement with the tech team.
Okay.
In short, in the agreement we had, it was clearly stated that the IP belonged to the tech team as a result of the fact that the funds required for us to be, to own the IP was very high. So now, let's assume we're able to raise funds now and we want to go into negotiations to own the IP. What would you advise for us to be at advantage? Because right now.
Wait, but again, it depends. Did you tell them to sign the contract and they refused?
Signing
was it a contract in the first place?
No, the contract we had, it was stated there that the IP belonged to the tech team.
So, are you not the tech team? Is that not what you said?
No. Yes, we contracted the tech team.
Who drafted the contract again?
Funny enough, we did.
Wait. The tech team drafted the contract?
No, we did. No, there was no lawyer, actually. Yes.
Was it AI?
You've said it all. It was actually AI.
It's a good thing that he has said it on record, and the guy here is recording. It's AI that's put him in trouble. So what I would say is, since you guys are the ones that drafted, you can simply tell them that you guys are just sending the contract again, administrative, whatever, that, you want them to sign again. You get, as long as you guys were the ones that drafted initially, and are you guys owing them? You're not owing them. So you're like, that they can sign the contract again so that you guys can now document it. You can say whatever you like about the previous contract. But as long as you're not owing them, you don't have anything you're contending with them, it shouldn't be an issue. Because again, they are business people and they were happy that you gave them a contract, right? Yeah, so they will also be happy that you might give them something again in the future. So that shouldn't be too much of an issue. But in the future, do not use AI to draft those type of things. AI usually doesn't account for these nitty-gritties. It usually does not. Just even getting someone that just finished law school and giving him 100,000 would have saved you this trouble. It would have saved you the trouble.
Okay. Good evening, everyone. So my question goes thus. So in the case where you have a founder or a member of the team who has started working on a project, and then you get a contractor to come join on the existing code base. So maybe you worked on some parts, half or whatever percentage of the code. So would you say that he owns, quote unquote, the full IP, or would he lay claim to just the section he worked on? How would you quantify that?
Justice demands that he is only able to own the section he worked on. That's what justice demands. But again, the way code bases work, I think you're a technical person, so you should know that it gets mixed up. So I mean, it's very difficult to even say that this is the part this person worked on, and this is the part the other person worked on. Oh, okay, unless that. But either ways, I think that just not to get into those type of headaches where you're not expecting old judges to start looking at the code base to decide who owns what. I think I think it's useful to just have a clear contract from the beginning. IP belongs to the company. We're just engaging you to work on something small. And when you're done, then we are done with our contract. If we need you again, we'll pay you again to come on board and work on the other aspect. It just makes things more tidy. Makes things more tidy. Because again, that person that is working on a segment of the code base can as well switch off something that would delete all his segment as well. If he feels unfairly treated or you withhold his payment and so on. He says it's not possible. Fair enough. You are the technical ones. I'm not the technical person.
Okay, I think we've taken enough questions, to be honest. So thanks so much, Osita. So, I mean, legal sessions are always it usually drags on because there are always very interesting nuances that you need to account for. So I guess my final words would be: shut talk to a lawyer, don't talk to AI. Yeah, just talk to a lawyer, and hopefully you are not too far gone in the process that there's just no way back. I guess that's it. Thank you so much, man.
Yeah, you're welcome. This was a pleasure.